As we had predicted on the show, this morning, the Supreme Court ruled once and for all that states cannot remove Trump from the ballot under the 14th Amendment. Though that is not to say I'm Nostradamus, because when they were hearing arguments and talking, it seemed pretty obvious where they stood. And while I thought there was a chance that maybe it wouldn't be unanimous, it was a unanimous decision, with SCOTUS striking down the ruling by the Colorado Supreme Court that had removed him from the ballot for his role on January 6th, or which they argued could be done under the constitutional provision that bars insurrectionists from holding office. And this is a big deal because it goes beyond Colorado, with the ruling also applying to two other states that have made similar calls to remove Trump, Maine and Illinois, as well as impacting numerous other efforts that were still making their way through various state legal systems. And as far as the specifics, in their majority opinion, 5 of the conservative justices wrote that the Constitution does not give states the power to disqualify federal office holders and candidates, arguing that responsibility rests with Congress and not the states, and warning that chaos would ensue if a candidate for nationwide office could be named ineligible in some states but not others based on the same action. And adding, nothing in the Constitution requires that we endure such chaos, arriving at any time or different times up to perhaps beyond the inauguration. But this notably, while yes, we had a unanimous decision, you had some justices arguing that the majority decision went too far, with the court's 3 liberals writing a concurring opinion where they said that the federal enforcement of Section 3 is in no way at issue in the case, but saying the majority still made a decision on a question of federal enforcement that wasn't being asked of them anyway, and arguing that the decision will foreclose future efforts to disqualify a presidential candidate under that provision, and saying in a sensitive case crying out for judicial restraint, it abandons that course, and accusing the conservative majority here of trying to insulate itself and Trump from future controversy. And actually, very notably here, we also saw Justice Amy Coney Barrett distancing herself from the majority here, agreeing that she thought her conservative colleagues went too far in deciding what Congress is required to do to disqualify someone from office, saying the Colorado lawsuit did not ask the court to, quote, address the complicated question whether federal legislation is the exclusive vehicle through which Section 3 can be enforced. But then she also went on to chide her liberal colleagues for their harshly worded opinion, arguing that, quote, writings on the court should turn the national temperature down, not up, and adding, for present purposes, our differences are far less important than our unanimity. All 9 justices agree on the outcome of this case. That is the message Americans should take home. And there is some truth to that. For now, this is the biggest thing that matters, with some describing this as the court's most important ruling concerning a presidential election since Bush v. Gore handed the presidency to George W. Bush in 2000. Though notably, that title may get passed down to the next case the Supreme Court is going to be hearing, which is, of course, whether Trump has presidential immunity from federal prosecution in the federal January 6th case, which again, as we talked about, is a win-win for Trump. Even if he loses that case, which is a decent probability, it would prove to be an incredibly important and consequential delaying tactic for Trump, since it very possibly could push that case, or at least the result of that case, till after the election.